for in the Open Public Meeting Act have been satisfied. Further, I direct that this announcement shall be placed in the minutes of this meeting. Notice of this special meeting was properly given by the West New York Zoning Board of Adjustment on April 8th, 2015. By publishing in the Jersey Journal, publicly posting in the Municipal Bulletin Board, and filing with the Town Clerk. Is that correct, Madam
Correct.
Secretary? Thank you. The next item, and this is a matter of housekeeping, is just an announcement that we will have a special zoning board meeting on Wednesday, May 6th. That's Wednesday, May 6th, and you'll hear more about that because possibly we'll adjourn one or two things to that date. The first item on the agenda relates to the 10th Avenue Holding LLC request for, the agenda says an interpretation of, I guess, of a former memorializing resolution. That to me is a very slippery slope, so we're not going to do this as an interpretation. We're going to take this as an application to amend, an amendment of the previous memorializing resolution. Mr. Alonso?
Good evening, Mr. Chairman,
Good
members of
evening.
the board. For the record, Alvaro Alonso Navarrete of the 10th Avenue Holdings LLC. My client is a contract purchaser of the property, which is subject to these two approvals. You recall there was two separate approvals, one on 53rd Street, one on 54th Street. One was for 28 units, one was for 52 units. As part of our due diligence in the contract purchase, we reviewed the approvals that are obtained. In reading the transcripts and the resolutions, I noticed that there was some conversation before the board with respect to HMFA financing in order to be able to sell these as affordable condominium units. These approvals were obtained back in the time when developers were building condominiums, as opposed to nowadays in building rental apartments. The HFMA money has dried up, there is no money available anymore. And the reason I raise it as an issue is the applicant at the time was Iman through two of his entities. Iman also did the Jacqueline Properties application, and he also did the one on 70 units on 52nd Street. Those had specific conditions in the resolution that it was for HMFA financing and it were to develop affordable units. The other thing I noticed in this application when approved, it was not presented as an inherently beneficial application for the affordable units. It was essentially the development of the multifamily buildings. But since there was some testimony, some questions, some back and forth with the board, I thought it'd be important to come back to this board to get an amended resolution reflecting that the affordable units was not contemplated as part of the approval granted by this board.
Thank you very much. I would ask our attorney whether he has in fact reviewed this application.
Mr. Chairman, as an initial matter, I just want to mention I reviewed the applicant's notice. The notice was legally sufficient, so the board has jurisdiction. I did review this application, and it is my legal opinion that this is properly a request for an amended resolution of approval. As noted by the applicant's attorney, they're seeking an amended resolution of approval with the notation that this does not, there's not a condition of approval involving affordable housing.
Okay. That being the case, does any board member have any questions regarding either Mr. Alonso's statement or the recommendation by our attorney? Not seeing any, I'll move it as recommended by our attorney, amended memorializing resolution under the conditions that he, an amendment that he expressed. And ask for a second. Is there a second?
Second.
Roll call, please.
Kenneth Blaine.
Yes?
Rose Porto. Yes. Ramon Morejon.
Yes.
Jesus Alvarado.
Yes.
Alberto Chavez.
Yes.
Alvaro Martin.
Yes.
Mohammed Al-Mansur.
Yes.
Thank you very much.
Also, as a matter of housekeeping, under the new agenda, we have number 12, new applications, 6401 Park Avenue investment. Regarding 6401 Park Avenue, is there anybody here on that?
Mr. Chairman, now for the record, Alvaro Alonso, on behalf of the applicant.
Okay, what is this about?
This is an application that was previously on the agenda and was put on for today. My understanding is that the board wanted to concentrate all of its time on the Meridian application, so we're going to be requesting that the matter be carried.
Okay, why don't we carry this to the special meeting on May 6th? Is there any member of the public here regarding the 6401 Park Avenue application regarding property located at 6401 Park Avenue? I don't see anybody coming forward, but if they were, I would tell them also that this matter has now been postponed to the special meeting on May 6th and no further.
There were some procedural issues with the notice, so I've asked the applicant's attorney to renotice for May 6th.
Okay, so there will be a re-notification of the appropriate people regarding the special meeting on May 6th.
Thank
Thank you,
you.
Mr. Alonso. Now, the last thing we have on our agenda is the Meridian, is a continuation. The last thing we have on the agenda is the continuation of the Meridian Boulevard application. As I understand it, we have approximately 9 members of the public that still have to comment. So I would ask them to come forward. The first one is Amy Orlando. Let me say for the record that there'll be a time limit of approximately 5 minutes. We'll see how that goes. Certainly if you do 4, that's fine. If you do 6, that's fine also.
What if I do 20?
You won't. Trust me, you won't. Let me put it this way. Since you know there's a time limit of 5, I would ask you to prioritize your ideas, because my understanding is that there has been somewhat repetitive or duplicative comments.
And may I, just for the record?
Absolutely.
Just for the record, everyone's edification, I want everyone to know that we're trying to do this in the most fair way. I'm going to read some from some case law from our courts, and the first is: the board retains discretion to limit testimony and cross-examination in a reasonable manner. That's Lincoln Heights Association versus Township of Cranford Planning Board, 314 NJ Super 366. 314 NJ Super 366 at page 384. More importantly, this is from the Cox Treatise on New Jersey Zoning and Land Use Administration. If a number of objectors jointly hire an attorney, such objectors can then properly be heard only through their attorney, although each of them may testify as long as their testimony is not repetitive. My Cox book is old, so that's Cox 2012, section 27-3.4. So, what I'm trying to get across to everyone in the audience is that I believe the chairman has gone above and beyond to allow a lot of testimony and comments, but we need to limit it to 5 minutes tonight to try and wrap things up. 5 minutes per person.
On that note, is Ms. Orlando available?
I am.
So, please come forward. And again, I would ask you, since you understand the time limit for tonight, I would ask you to prioritize your ideas. Yes, ma'am.
Okay.
Please step forward. What? Sure.
Or, I don't know how we do it.
Yeah, because we have cross, if necessary.
Raise your hand. Do you swear the testimony about the truth and what you're doing?
I do. Amy Orlando.
Yep.
But I was kidding before, by the way. About the-
I always take you seriously.
Well, that's actually a good. Okay, so, for the record, I have prioritized my comments, and I don't.
Would you speak into the microphone, please?
Where is that?
I have prioritized my comments, or at least I've tried to.
Let me ask you something, is that one easier for you?
I don't know.
That one goes
Because-
longer though, I think. That one's longer.
Really? I thought that one was.
No, this one's longer. I guess. either one.
Is this one working?
Yeah?
Oh, I think that you.
Go ahead.
Okay, So, everyone's been here many times, and I have to say that for me the question is, what is the benefit to the town of West New York? So far, I have heard about one new job. I have also heard that the master plan does not rezone those parcels to accommodate more housing units. I also still haven't gotten an answer about why we would want the dubious distinction at best of being the first building on Boulevard East that's high-rise to high-rise. I frankly think there's no benefit, and frankly, I believe there's a detriment to the town of West New York, both the town and the residents. The only benefit is to the developer. I am very concerned about the lack of affordable housing units that have not been addressed to my personal satisfaction. I don't believe they've really adequately been addressed for this board. And further to that, the applicant is not even a current owner of the parcels, which I know does not disqualify them from coming before this board. And that they do own another parcel in town, but they have had tax abatements on that parcel in lieu of tax payments, according to the ordinance number 15/11 of the town of West New York. And this La Meridia property on Park Avenue, which I don't know the specific address of at the moment, according to the tax payment schedule for the tax in lieu payments, for the first 5 years, let's see, the first year the deficit is $396,000 to the town, followed by an additional $249,000 in tax payments in lieu of money, $155,000 for the third year, and another $76,000 for the fifth year rather. This is not a small amount of money that has already been granted to this developer, and at great expense to the town of West New York. That building currently still has a continuing certificate of occupancy and many outstanding building code violations. I'm not going to go into them because I'm sure we don't need to. So while we do not know whether or not they will apply for tax abatement for 7 years, they have done this very thing for other properties by this very developer. There's no guest parking spots. They will also, further to that problem in West New York, be eliminating existing parking spots. They will be shading the entire block of Boulevard East most of the day, year-round. And then I come to that neon M sign, which frankly, in my opinion, is like a bat signal in the sky. It makes it look like a bordello. If this application is approved, I would respectfully request that the board kindly ask it to have it be moved to the west side of the building, because there's no benefit to anyone in West New York but the free branding and advertising for the development. No one in Manhattan will ever see that M, only the Versailles residents. As far as the COA units are concerned, it is not unsettled law. It is law. However, what is unsettled is how the law is applied. So there are no COA units for this project, which means the town of West New York will have to do something at some future date about that. That typically means paying funds to another town to compensate for the lack of affordable housing.
Mr. Orlando, I'm not going to take your time, but I just got...
But you are.
No, actually,
Okay, go ahead.
the
I'm
clock
sorry.
is stopped.
Thank you.
I just got a blurb from one of the law firms that my building deals with regarding the new affordable housing COA decision by the New Jersey Supreme Court. And essentially, my understanding is what they've come down and say is there's no definitive amount And that what has to happen is that anybody that objects to what a town is not doing has to sue that town.
Awesome.
I understand what you're saying. I understand what you're saying, but my understanding is from this law firm that that's really what's come down from the New Jersey Supreme Court, and I suppose that it's gonna be on a town-by-town basis. But the activists that are interested in COA are gonna have to take it upon themselves to sue the towns now to get this done. Please continue. I just didn't want you to continue because.
I understand, you were trying to reserve my time, and you've read
wasting your
the,
time.
I understand, and I appreciate that, but having not read
I understand.
the ruling, I'm not gonna comment on it. Okay, so I'm still gonna continue to be concerned about the COA requirements personally. And perhaps I will have to be in that unfortunate position to institute such a suit against the town as a taxpayer. But that's neither here nor there because we're not there yet. In addition to which, I have not heard any public comments on the record that are in favor of this development. Not any. So if these units are to be luxury units, why aren't they gonna sell these units to owners instead of rent them? That's a question I haven't gotten an answer to either. Owners, like at the Versailles and Halifax Hall and Tower West and Riviera, I could go on, and as in other towns, have invested in their community. Tenants who rent are only as invested in their community for only as long as their lease runs. We have taxpayers at the Versailles and renters at this new La Meridia. The tax abatement question has not been answered. I am confident personally that since they applied for the other property to get the tax abatement that they've developed in town, they will do so here too. But that remains to be seen. But if this developer is so invested in the town of West New York, why doesn't he purchase the lots he proposed to develop? Why is it contingent on the sale? I have a very big issue with the branding. There's no benefit to West New York. The only benefit is to the developer. As far as I'm concerned, there is not an inch of property that is not being developed. It goes into the public right-of-ways, it goes into the street, and why aren't 80 units to the acre enough? Again, we have no answer from them. Mrs. Dato appeared before this zoning board in opposition to this very developer's previous proposed development on the lot then adjacent to her home because of no setbacks and her beautiful, probably specimen old trees that would be destroyed. Mrs. Dato's home, that block and lot number currently are included in this proposed development by the same developer. I wonder why she changed her mind. I can only guess it's money. And that may have swayed her to change her opposition. But this should not be about greed. This should be about the residents of West New York and what's in the best interest for all the residents. So, I implore you to say no. Just say no. This application does not benefit the town. In fact, it's nothing but detrimental to the town. It's going to be detrimental to the traffic. It's going to be detrimental to the parking. It's going to be detrimental to the commuting. It's going to be detrimental to the trash. The only benefit to be gained is for the developer. And frankly, this board's obligation is not to the developer. It's to the town of West New York. So I implore you to have the courage to stand behind what's right for the town. Not necessarily any one resident or one governing elected official, but what's right. Do what's right. Please do what's right. And if you look into your heart and you look into the zoning laws, you cannot come down any other way, in my opinion. So thank you for your time,
Thank you, Ms.
and I urge you
Orlando.
not to approve it.
Greg Arnold? Greg Arnold? Greg Arnold's not here. Vincent Liebhardt?
Yep.
I was close.
You were very good.
Good evening.
Raise your hand. You swear testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Good name, spell your last name.
Vincent Liebhardt, Liebhart. I wish to thank. Address?
Address, please.
6701 Boulevard East. I wish to thank the members of the zoning board for volunteering their time in what one would hope is an effort to protect the citizens of West New York. How many hours have you and many of my neighbors spent over the last years listening to the details of the development of the property on the corner of 67th Street and Boulevard East? As a result, it is evident that the developer, Capadogli, designed this structure in direct violation of all or most of the regulations that are meant to protect our neighborhood. The developer, Capadogli, not from West New York, offers nothing in return that would benefit those of us who live here. Capadogli's motivation in crowding this too large building on a property of inappropriate size seems to be nothing more than gain, financial gain. If the board were to approve this structure, it would be irresponsible and suspect. Capadogli provides no give back to the community. What are those of us who live here offered in return? Please make note, like you board members, a considerable number of my neighbors have sacrificed many hours to come to these meetings and have voiced their valid objections to the structure. Not one citizen living in the neighborhood has come forth in favor of it. Only the so-called experts paid by Capadogli have argued in support of this design. I would like to remind the members of the board that their responsibility is to protect the interests of the citizens of this community. The members of the board need to look to what advantage this development will have for those of us now living here. It would be irresponsible for the board to vote to enable this outside developer to flaunt the regulations meant to protect the properties of those of us who are established citizens of the community. One hopes that you, the members of the board, will turn down Capadogli's request for these waivers, since it is evident that it will have a permanent negative impact on the quality of many of our lives. If that turns out not to be the case, I ask you, each member of the board who chooses to vote in favor of the structure, not to cast such a vote without first making a clear statement to me and my neighbors, explaining how you have come to such a decision, and be considerate enough to clarify your reasoning so that those of us forced to look at this structure every day will have some understanding of your logic and perhaps forgive you.
Thank you very much. Is Emily LeBear Warren here? Emily Labor Warren? Emily Labor Warren, okay. Georgette Kovacs,
Yes.
please step forward.
Georgette Kovac, 6600 Boulevard East.
Raise your hand. Swear testimony about to give will be the truth, the whole truth, and nothing but the truth. Yes.
I'm a resident in the town of West New York and living in the Versailles for 28 years. This massive Meridia apartment complex will be a horrific mistake for the boulevard and the town of West New York. You have been listening to all the objections, which I don't need to say again, I'm sure, as to why Meridia should not be a part of Boulevard East and how it will be especially harmful to our neighbors and the quality of life in the town of West New York. We don't want Meridia to become a standard by which future development of our town will be judged. I urge the zoning board to vote no on this proposed building. Thank you.
Thank you. Oswaldo Gonzalez.
Is not here.
Okay. Flor. No. Flower Girado. She's been here before, because I remember. I mean, this is a very unusual name. She's not here now? Okay. Carlo Mosara?
He's here, but
I think maybe the
could we get him up here?
microphone could reach.
Sure, if the microphone can reach, that's fine.
This one, it's really long.
Really?
That should reach.
Yeah, it should. There's a huge bag on top of it.
All right, I need to state his name and address for the record and spell it.
Mosara Carlo, M-O-S-A, first name is Carlo C-M-O.
Address.
The home address is 6600 Kennedy Boulevard East, apartment 17
At?
Right.
Right, okay. Can you raise your right hand, please? Do you swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Thank you.
Okay.
Thank you, sir. Please continue.
I call Mosara reside at 6600 Boulevard East, apartment 17 I'm sure the places in West New York and what foods to the project. And just look around. My suggestion is to relocate to a different complex. And let's be aware of the light pollution problem as well as an increase in efforts to over like groups. I also don't look forward to I also don't look forward to the dirt and pollution, noise, and destruction. We're all in the same boat.
Thank you very much.
Copy of that.
Thank you. Margaret Gaffney?
Margaret and Daphne, Hughes and George, A. Left and Frank, and Noel. 6600 Boulevard East.
Can you raise your right hand? You swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good evening.
Good evening, and welcome back. I'm glad to see you're looking well.
Okay, thank you.
I have to say the planner did a masterful job on provide the benefits because he managed to take one of the biggest negative aspects of this and tell you it was a positive benefit. He told you that this development would fill a void. In reality, that void, as anyone who is familiar with the area knows, is an area of light, air, and open space, the preservation of which is an objective of both the New Jersey Municipal Land Use Act and the West New York Zoning Code. This area includes, as I believe Georgette mentioned, close to a dozen trees which are almost as old as the town of West New York. I see on the seal the town was in dates to 1898. These trees cannot be more than a dozen years younger than the town. To plant trees today, their replacements would be younger at the town's bicentennial than these trees are today. And that would be a tremendous loss to the town. I won't go over the strain on the traffic, the lack of parking. You've heard that ad nauseum. This building, we heard testimony that it will not block anyone's view. That is flatly wrong. It will block my view. Right now, the major attraction of my apartment is, and that of the other 127 people who live on the west side of the Versailles, is the gorgeous sunset view we see from our apartment every evening. Almost no one would see it. Those who see it would have only a partially obstructed view, whereas virtually everyone can see it completely now. It would also block the morning view of the private homes on McKinley. And now that once the trees went down, I saw that each of those homes has a balcony on their second floor, from which they can sit out in the summer and enjoy the wonderful evening air. And they can see Manhattan from their balconies. They will not be able to do so. Instead, they will practically be cheek by jowl with the windows of the apartments in this proposed development. This is obviously detrimental to the property values of their homes, as well as to those of us in the Versailles. It will completely block the views of the people in Halifax House, and it will block the upriver views of those in Harbor Tower. All the people I have mentioned are homeowners paying property taxes to this town. I just did my taxes last night. I'm paying in excess of $5,000 a year property tax, and I pay less than the average Versailles homeowner. Carlo is one of our residents who enjoys sitting out in front of our building in the afternoon, soaking in the sunshine. There will be no sunshine for him or anyone else to soak in if this building is put up. This again is a detriment to the residents of West New York. I don't think anybody's mentioned the sewage treatment facilities. This will put a great strain on it. When I moved here 16 years ago, and my apartment sits right over the sewage treatment plant for the town, it was operating at 130% of capacity, and it stank to high heaven. Thank God I do not have a good olfactory sense. We doubled the capacity, but there has been so much development in the interim that I'm afraid we're going to be back in that situation before very long, especially if projects like Meridian Boulevard are passed. So I've enumerated several ways in which this will adversely impact the quality of life for our residents. I haven't even mentioned the Red M. And if you think that's not going to be a problem, just talk to the people who live on the west side of Park Avenue by the Meridian Park where we have it, or the people on the west side of Monitor, and they'll tell you about the red light shining in their bedrooms at 3 in the morning, disrupting their sleep. And we'll have close to 200 additional people being subjected to that if this project goes up. And in turn, what are we getting? We're getting a program which will literally steal money from the school board, because when they get the tax abatement, let's face it, the Board of Commissioners has never met a request for a tax abatement that they didn't love. The taxes that are currently being paid on that property that go to both the school board and the town, the county, will drop to 0. You paid a tax increase last year, and that's why, because of all these pilot programs where the school board and the county, let alone the reduction in what the town should have been getting that Amy talked about. We're talking about an actual decrease in tax revenues for the school board. And frankly, I think there's nothing more important than a well-educated citizenry, and we cannot afford to be reducing the taxes that are going to the schools as this and all the other developments in town are actually doing. So even with 0 children, this will have an adverse impact on the schools of West New York. So for these reasons, I urge you, please, please vote no. Thank you.
Try one more time, Greg Arnold. Not here. Emily LeBaire Warren. Nobody's coming forward. Oswaldo Gonzalez. Nobody. So Someone was shaking her finger at me.
Maria, who else?
And Flower Gerardo. Okay, none of them are here. This concludes the public comment. The next portion of the application would be the objector's planner. Is Mr. Kantrowitz here?
Yes, thank you.
Please step forward.
Yes. Mr. Chairman, may I use the railing?
Absolutely.
Thank you.
Whatever you feel is necessary.
Thank you.
Come up here if you need to.
Thank you. That would be helpful.
Yeah, okay. Good evening, Mr. Chairman, members of the board, members of the public. My name is Jeffrey Kantwitz.
Good evening.
I have tonight, excuse me, Mr. Craig Rahenkamp, who's an expert planner. I'll ask him first to go through his curriculum vitae resume. If there are any,
I got to swear in first.
I'm sorry.
Just spell your name for me.
It's Craig, C-R-E-I-G-H, Rahenkamp, R-A-H-E-N-K-A-M.
Raise your right hand.
Can you do that again, Dave?
Sure. Craig is C-R-E-I-G-H, Rahenkamp, R-A-H-E-N-K-A-M, as in Michael, P as in Peter.
Raise your right hand first. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
It will. And it's not my fault, my parents did it.
Mr. Chairman, Mr. Rahenkamp has been in front of this board before, but for purposes of completeness of this record and because there are new members hearing this application, I think it purposeful for me to ask Mr. Rahenkamp his background qualifications, then afford the board members and/or the applicant and/or anybody else the opportunity for voir dire and then continue with his testimony. So with that,
I agree with you completely. Mr. Ramchamp, please give us your educational background and experience.
Good evening. I've been in the field of planning for 33 years. I've been licensed in New Jersey for 19 years. Education started at the University of Pennsylvania at the undergraduate level, then went to the University of Wisconsin, back to Princeton, back to Penn, and I'm currently a PhD student at the Maryland Department of Real Estate Development. So continuing education, lifelong. In terms of planning in New Jersey, I was a consultant to the Department of Community Affairs on the residential site improvement standards. I served as a court-appointed master on affordable housing cases. I've qualified before the Superior Court in over 100 cases in New Jersey. I was a field expert for the PP, the planner's exam, and I'm adjunct faculty at Rowan University. Hopefully that's enough. Otherwise, I'll go on.
Just
No,
one question.
no, much more important.
Municipal board testimony, have you testified?
Much more important, much more critical. You were qualified by this board previously, isn't that true?
Yes, sir.
Does any board member have any questions regarding this proposed expert planner's educational background or experience? Not see any questions by any board members. I'll qualify you as such an expert.
Thank you, Mr. Chairman.
Mr. Rahenkamp, one question before you begin. You said you were a master, court-appointed master in affordable housing cases. Could you just spend a minute explaining what that is, and if you know how many people around the state serve as court-appointed masters in affordable housing cases?
I believe there are less than a dozen currently active planners who have served in that role in New Jersey. Basically, you are serving as the court's expert in litigation. Judges receiving affordable housing cases have to get into land use issues in a very detailed way. So essentially, the court hires a planner to help them understand setbacks and all the issues you guys are dealing with in most of your applications, an assistant judge in understanding those issues. So basically working for the judiciary, assisting the judges.
Thank you. Okay. Happy to continue. Would you continue your testimony in terms of your work on this matter, background, familiarity with the area and so forth?
Yes, sir. Mr. Chairman, let me apologize for the water. I recently had some sinus surgery, so I need to keep lubricated as we go. So I apologize for bringing that up with you. But
I understand completely. I had tongue cancer.
Ooh. You win that contest by a long shot.
11 hours, thank you.
Oh, my God.
Please continue, though.
Yes, sir. I won't try and top that, I promise. In terms of my role, you've heard a lot of testimony from residents on a series of issues. It's not my intention to duplicate those before you, but to spend time on the more technical aspects of the application, things that a planner can bring to bear that you wouldn't otherwise have heard. The applicant has described the relief as 3 different Ds for FAR, density and height. And there are a variety of C2 variances, coverage, lot dimensions, as well as relief under the residential site improvement standards. All of the C and D variances share the same relationship to the negative criteria. I'm sure you've all heard this 1,000 times. And most of that relates to the kinds of testimony you've already heard. You've had, for example, a photographic essay from an architect of the buildings in the particular neighborhood. You had a lot-by-lot analysis of bulk standards on existing lots, establishing the context area. Photos of views from individual units, and numerous other concerns from residents that go to the impact of this application on the neighborhood. But the other half of the negative criteria is the impact of this application on the intent and purpose of your zone. And that's where I intend to spend the majority of my time this evening. Sorry for the voice. In order to prepare, obviously, I've attended all the hearings. I reviewed your zoning map. The zoning ordinance as it exists today in its online condition. Sorry. There are 2 particular ordinances that were significant. Ordinance 1326 from January of 1979, which put the zone plan in place here, and Ordinance 1771 that established parking for multifamily in 1987. Sorry.
It's okay, we're used to people feeling overly pressurized by hearing before this.
I promise it's not the pressure, it's my throat's closing.
I'm kidding. You know I'm kidding.
It is embarrassing, nevertheless. Anyway, there was a re-examination report that I believe.
Let's do it this way. Let's have, Mr. Jankowicz, let's have an ongoing, I'm sorry, so that
I won't do
anytime in
it
the
ever
future, all you have to do is take the water, you don't have to say you're sorry anymore.
Thank you, sir. You're very kind. There's a 2001, I believe, document, re-examination report. I reviewed that with Mr. Layton when he was your planner. I don't have a copy of that. The date was not on the cover, but documents since then have referred to that as the 2001 re-examination report. There's a re-examination report from 2013, and obviously the master plan, which ultimately became the 2014 master plan. I was originally engaged back in 2012. I visited the site multiple times to observe the corridor on a number of occasions. So before I get into the variance testimony, there are 2 aspects of this application that I think are deficient, and a resident just raised it again, and the chairman responded to it, and that's this issue of affordable housing. It is certainly true, as the applicant answered a question 3 or 4 hearings ago when the chairman just observed, the Council on Affordable Housing is in chaos. The state agency that's responsible for this area of regulation has been dysfunctional for about 15 years. There's recently been a Supreme Court decision, and I would agree with everyone that it's complicated. Nobody really knows what the number is, but none of that is germane. You have an application before you, and an applicant is required to follow the ordinances that have been adopted by a municipality. COA's regulations have never been directly applicable or regulatory on an application before a board. In this community, you have a series of ordinances that have been adopted and not rescinded. And whether the applicant is going to follow them or seeking variance from them, they have to do that in front of you or with testimony before this board. Okay.
Do you want to loosen your tongue?
No, I'm good, thank you.
Okay.
It's on the inside that it's shutting down.
Okay.
Section 414-111A requires the submission of what's called an Affordable Housing Production Plan, the AHPP, at the time of application. It's explicitly a completeness requirement, and while the ship has clearly sailed on whether or not this application is complete, given that we're at the end of the hearings, it's certainly a document that's been identified as being important, significant, a completeness requirement. And I think clearly the board deserves to have that before you before you would determine whether they are entitled to D-level quality relief from your ordinances. Under paragraph B of that section, it specifically says that the HPP, this document, is to be reviewed and approved by the quote-unquote board hearing the development application. The applicant, in response to a question, said they'd work something out with the governing body in the future. Well, that's not what the ordinance calls for. You are the board that has jurisdiction over this issue, and while it's appropriate for you to seek guidance or information from the administration or elected officials, ultimately you have to determine on this application whether you're going to hold them to the ordinance that's in place or grant them a variance to allow them to do something else. Section 414-105 establishes a set-aside of 1 affordable unit for 8 market rate units. That clearly marks it as an ordinance from the early part of the prior decade. It's an early growth share ordinance, we would call it. And while if I were an applicant for a by right use in your community, I'd complain that somebody's making me do a set-aside for a by right application. However, you've got an applicant before you seeking multiple D variances. And throughout the state, the planning profession, typically when we see D variances, you start with the assumption that an applicant is going to do 20% set-aside. They're asking for substantial relief. A 20% set-aside is the normal that goes with that. So whether they're following your ordinance or doing something in relationship to the variances, that there has been no discussion of what they're doing is extraordinary. And lastly on this, section 414-106 establishes a priority for on-site compliance and describes alternative techniques, including payment in lieu that a developer can opt to choose instead of doing them on-site. But whatever it is they're doing has to be included in the AHPP under this provision. So the bottom line is this board can't punt this issue. This isn't an issue before you. There's an ordinance to be enforced or varied, and you've had absolutely no testimony to the applicant why the ordinance should apply to them, other than saying the world is in chaos. Nevertheless, there's an ordinance in place, and some response needs to be provided. Promise I wouldn't say I'm sorry again. The second issue is the residential site improvement standards. Essentially, the applicant, the issues around this relate to dimensions in the parking garage in terms of drive aisles, parking stall sizes, and the number of parking spaces. The request for a de minimis exception is procedurally deficient. Under NJAC 5:21-3.1b, it requires that an application for exception be in writing, and that include 3 specific elements. A statement of the requirements from which the exception is sought, a statement of the manner in which strict compliance would result in practical difficulties, and a statement of the nature and extent of those practical difficulties. So they have to actually tell you not only what the standard is, what it is they want to do, what the problem is that's forcing them to not comply with the RSIS. What are the practical difficulties that they face? And the applicant could argue that they put on a chart on the plan what relief they need the exceptions from, and that's in writing in theory, it's on the plan. None of that included a discussion of the practical difficulties. And you've heard no direct testimony tying practical difficulties on these issues to relevant land use issues to allow you to grant an exception from the RSIS. With regard to parking space number, the applicant has started their application by saying they were complying with RSIS with regard to the total number of parking spaces. However, the board is allowed to come up with an alternative parking standard, looking at household characteristics, availability of mass transit, urban versus suburban location, and availability of off-site parking resources. Availability of off-site parking resources. Their traffic engineer started off very well. Brought a lot of really good demographic information to you, interesting census material, car ownership information. Unfortunately, he stopped short. There was no analysis of off-site parking resources in this neighborhood. No study to say what the impact of this was going to be on parking within the overall neighborhood. Now, the reason this is important is there is a requirement of the residential site improvement standard that the applicant didn't address. footnote B of table 4.4 requires that of the parking that's required, half the space per unit, this is not on top of, but part of the universal parking, has to be provided, quote, on-street or in common parking areas, unquote. How do you address the requirement for guest parking that needs to be in a commonly accessible area if you've never studied the resources? They haven't presented to you what kind of guest parking availability is available in the area and what their response is on the guest parking issue. Now, this is significant, not only because you've heard from the residents that there is a deficiency of parking in the area in general, but because this half space requirement is essentially half the space that they're providing in the garage. So even if they were to say to you convincingly that they could provide the equivalent of common access to guests in the garage, you're using a substantial amount of that space for guests that would not then be available for residents. On the issue of space size and geometrics, it's common when asking for relief from the residential site improvement standard to cite to other professional standards, other societies, organizations, the Urban Land Institute, the American Planning Association, the International Parking Institute, National Parking Association, the Green Parking Council. There are dozens of these organizations. One of these is the Industry Association for Parking Garages. They come up with alternative standards. What was significant here was that when Mr. Kanowitz cross-examined their witnesses, none of them could point to one of these standards that justified space sizes and the geometrics that are as tight and as small as are being proposed in this garage. And I can find none either that went down as low as what they're asking. So while it's common to get relief from RSIS on these issues, the extent of relief that they're requesting goes beyond anything I've seen before, and is certainly not supported by these alternative standards that we typically turn to. The bottom line here is I think that the practical difficulty is that you can't get a number of units on the site for which they require a variance from you anyway, unless they get the dimensional requirements given the relatively small size of the lot. If you have an acre-sized lot, which is required under your ordinance for a taller building, you have a large enough floor plate to provide reasonable circulation within a parking garage and reasonable benches. All of this is coming about because they're trying to put too high density, limited in the parking area on too small of a footprint. And I think your ordinance had it right by saying that you needed an acre in order to provide this kind of building with the kind of interior parking that would actually work. It's so much easier if I could breathe. So let me turn to the D-variant standards in the actual planning testimony. Where I think the applicant and I disagree the most is on the intent and purpose of your zoning plan. The obligation that you as a zoning board have to pay attention to what the governing body has put in place by the adoption of the zoning plan, what the intent was behind that, and whether this will actually frustrate you. Mr. McDonough did not, in his affirmative testimony or in his report, directly explain to you what the intent of the zone plan was. And it was particularly striking in cross-examination. Mr. Kanowitz asked him 3 times, what documents did you review to determine what the zone plan was? And 3 times he answered various aspects of the master plan. Not once in his response or in his report did he identify that the zone plan comes, the intent of the zone plan comes from, first, the zoning map. The zoning map and the zone plan are synonyms for one another. So you don't start with the master plan, you start with your zoning map. And looking at the zoning map, you come up with some very clear, I think, perspectives. The first is that the RH zone, the high-rise zone, where this community anticipates high-rise development occurring along this particular strip, relatively close to the river, is clear in the way the zone is crafted. The first developable lot as you come up the escarpment is zoned RH. Now sometimes that's between the boulevard and the escarpment being the slope, and then you have buildings up between the road and the slope being high. Where that's not the case and the road came to the escarpment, the RH district exists on the other side of the street. So on an east-west basis, there is never a place where the RH district occurs on both sides of the street. It's only one lot deep, the first developable lot as you came up the escarpment. Now that's not an accident. I think that's a clear principle of the intent of the zone plan, not to have tall buildings across the street from one another. And you see that very clearly by looking at the zoning map itself. Mr. McDonough's testimony spoke of the buildings in the neighborhood, and that there were various tall buildings around, some mid-rise buildings around. The point isn't that they're around. The point is, where are they in this particular fabric that's been set up by your zoning code? Where they are matters. You can have buildings side by side that have different zoning requirements attached to them because of their relationship to this river, escarpment, road development portion. Now that's the RH district, and it would be fair to say that the RM district, the district that this applicant is actually in, also allows 12-story buildings in the right context. Now the RM district is the largest zoning district in the city, and it applies in many contexts. It's not essentially a river district the way the RH is. It applies almost universally throughout the city in many neighborhoods. It allows for a mix of residential types. Townhouses and single-family homes, garden apartments if you have a half an acre, and taller buildings if you have an acre. It's a very forward-looking, it may sound funny saying that in 2015 about an ordinance that was developed in the late 70s. But it reflects a very forward-looking approach in planning, that you would have multiple kinds of intensities, mixes of uses that occur within the same district, instead of having individual districts that would be single-family, townhouse, or multifamily. They could occur as long as you had a sufficient amount of acreage to support the use. What's critical is that the size of the lot drives the use and not the other way around. So within the RM, we have 3 permitted building types and intensities. Row and townhomes, 3 stories, 35 feet in height, 60% building coverage. Garden apartments, where you have a 20,000 square foot lot, 2 stories in height, still 35 feet, with a 35% coverage requirement, 20 units to the acre. And thirdly, elevator apartments, where you have 40,000 square feet, 12-story building, 55 or 75% coverage, depending on whether you are providing indoor or surface parking. The trade-off in the intent of the ordinance is land-based. You get the reward of greater density and height as you assemble a larger tract of land. You internalize essentially the effects of the density and height into your development as you grow the lot, if you will, within the overall district. Now the applicant has taken the approach as they described it. You pick the use on the attachment, and you simply get bulk variances from whatever you do as you go across and look at the various columns. And you'll see in column 5, the tract size is one of those kinds of bulk standards that are identified as you go across the attachment. But what's also important is the tract size appears in 2 places. Under principal uses, there are notes, and those notes refer you to text in the ordinance. And in that text are the tract sizes. So not only is tract size a bulk requirement as you go across the table, it's specifically in part of the definition of the use within the notes that are in the principal use category. So that's why I say land size, tract size, is elevated to be more than simply a bulk standard. It's the key, if you will, to unlock the additional density or height that the ordinance may permit.
You know what, Craig, last time I saw you, you were talking to 1,000 people, and I don't remember you even having one.
Yeah, I know, this is a new experience. Not being able to breathe makes it fun. All right, last point on this. The mid-sized buildings, like the Halifax, played a very large role in Mr. McDonough's testimony in terms of describing the character of the neighborhood. And I think what's very significant is identifying that those are not permitted currently in the zoning district adopted in the late 70s. These buildings are clearly older than that. I can't tell you when they were built, but they clearly go back before the late 70s. So the community knew that there had been mid-rise construction in this area. Mr. McDonough's testimony about neighborhoods in New York and other places that have intentionally embraced mid-rise structures to the street as a common building going all the way down the block was explicitly not part of West New York's vision for this particular area. West New York adopted an ordinance and said, we saw those buildings, they're in this area, we're not authorizing any more of those. We want low-rise, single-family stuff, or high-rise where you have a large track, not any more of these mid-rise structures. So while they may be part of a discussion about what's in the neighborhood, clearly the community has expressed through its zoning ordinance, its zone plan, an intent to go in a different direction. Now, some of this becomes important because of the way relief has been communicated to you in terms of the applicant's presentation. On page 5 of the McDonough report, there's a comparison of relief as he measures it relative to the ordinance. And I would suggest to you that it's very deceptive, as it essentially assumes that the board's already granted the lot size variance before discussing all of the rest of the variances. It treats it almost as if it were some sort of sequential activity. For example, it's been said multiple times that 12 stories are permitted. They want 13 stories. What's one story between friends? But on a half-acre tract, 2 stories are permitted for a garden apartment. 3 stories are permitted for the underlying townhouse and row homes, where they're asking for 13. Well, clearly going from 2 or 3 to 13 is rather dramatically different than presenting this as going from 12 to 13. The same happens with density. You say, what's the density of a half-acre tract? It's substantially lower, obviously, than what's permitted on an acre. They said 80 is permitted if you have an acre. The 20 units per acre is what's permitted on a half an acre. But they don't say our density measured to 20, they compare their density to 80. Same with coverage. You get 75% with interior parking, where they're requesting 97% if you have an acre or more. On a half acre, you're only about 35%, where they want 97%. So the extent of the variances that they're seeking are substantially larger than the way they've been presented to you, based on what's permitted on the tract size that they actually have assembled. And I think the extent of those variances, based on the tract size, is what renders this utterly inconsistent with the intent and purpose of the zone, the way it's been structured. Now, there are a number of arguments that an applicant can bring to you, and what they're doing is contrary to the intent. One is that it's a new use. Governing body wasn't thinking about this when they adopted this back in the late 70s. But housing, obviously, is not a new use. The community has intentionally provided for a variety of housing types as long as you have the appropriate lot size. In the RH zone, you can already do high rises. So this is not new, this is not different. It's not creating a kind of housing that doesn't exist in the community. There's been no showing of inutility or hardship. The applicant has suggested, less in this application, I think, than in the former, that getting rid of the former gas station is a desirable goal, and that supports the idea that there would be variances. What has not been presented to you as part of this application that I've seen is an economic rationale that says that this particular lot to be redeveloped needs this extent of redevelopment to make that happen. That connection, that relationship hasn't been given to you, even though they continue to suggest that somehow replacing the non-conforming use is important. And as many from the audience have already identified for you, in this particular application, not only do we lose one non-conforming use, we also lose 2 conforming uses, one of which the Dado residence is a very strongly contributing factor to the character of the neighborhood, the trees, the architecture, and the other things that have been spoken about. And as I said, there's been no discussion at all that the scale of the variances that have been requested are in fact related to what would be necessary. From a planner's perspective, it's like the bootstrapping and the Mine Joel arguments, but they simply haven't quantified them or made them relevant to the presentation. The other issue is that there's been a change in circumstances, that what's before you is stale planning. It's too old, it hasn't been re-examined, nobody's looked at it. That's clearly not the case. We have a 2014 master plan that reflects a process that this community has been about now for the last couple of years, spanning the, 10 tenure of a couple of planners serving this board as well as serving the community. There are a number of passages in this document that I think are very helpful. Page 19, again, connects the desire of enhanced setbacks for high-rises, where high-rises are appropriate. There's an observation that on Park Avenue, for example, another section of the community, south of 60th Street has an open field which is lost north of 60th Street. They're identifying that the pattern of development south of 60th Street with enhanced setbacks is to be preferred. Page 20 calls Boulevard East the crown jewel of West New York. You've heard that a number of times. But this characterization is based on its unique aesthetic appeal, and that's meant to be preserved. What's more important is that page 31 links this finding of character to the generally ample setbacks of the high-rise buildings in this corridor. So you have a specific reference in the master plan that says it's the setbacks to the high-rises that have established the character of this corridor. So granting variances to have a high-rise with no setback is directly contrary to the policy findings in your master plan. Page 20 considers additional height in the RM district, something that should be considered. But they're talking in the discussion about going up to 5 stories, not 13. And it's further described on page 30, quote, for larger sites where appropriate setbacks can be achieved. So even where your master plan is saying, you know, we really ought to think maybe adding some additional height to the RM district, they want to do so in conjunction with appropriate setbacks. Page 21 recommends, and I quote, siting standards should be developed to allow high rises on appropriate sites provided they do not intrude on sight lines of existing buildings and their residents. Adequate separation must be provided between high-rise buildings to maintain existing views of the Manhattan skyline. And you've heard lots of testimony, photographs from people's windows about all of the views that this building will compromise. And views has been identified in your master plan as a particularly important consideration. In short, I would say, without reading the rest of your master plan back to you, a particularly rude thing for me to do, that it is essentially an affirmation of the zone plan. That this pattern of development and uses that was established in the 1970s has been re-examined, has been looked at again by your planning board, and found to be appropriate. That where they were willing to consider additional height on the western side of the community and other areas within the RM district, it's not to the extent to the height this applicant is seeking. And even there, it's inconsistent with the aggregation of larger tracts and the provision of ample setbacks, neither of which is occurring here. Now, as it relates to the specific D relief, for the floor area ratio, which is addressed on page 6 of Mr. McDonough's report, Mr. McDonough concludes, visually the building will not appear unsightly, overbearing, or out of scale with the context of the area. You've heard from a number of architects, engineers, and other residents in the neighborhood that they disagree with that. I also disagree with that in terms of the relationship of a 13-story building. You can't bootstrap these mid-rise buildings like the Halifax to say that those exist. They're not permitted anymore. The community's decided not to go that route, but that established the character for a 13-story building in the midst of them was testimony, frankly, that I found unpersuasive. Mr. McDonough concludes that it's not a substantial departure from the intent and purpose of the zoning district. Again, he had never described what the intent and purpose of this zone was, and obviously I disagree with that characterization. With regard to density, on page 7 of Mr. McDonough's report, the requirement of Grubbs v. Slowthower, the controlling case, is you have to accommodate the problems that are created by putting additional density on a site. Mr. McDonough's report addresses a single issue in that section, and that is its fiscal impact. You've heard from the residents that they question whether the fiscal impact is appropriate given that there may be an application for tax abatement. I'm not even going there. Fiscal impact is not a reasonable basis on which a board such as this can grant the variance relief anyway. It's cheating to try and find a way to slip that into a report and say, here's my carrot, it's really good. It's got nothing to do with the criteria of ameliorating the effects of density on the neighborhood. And there is nothing in his report, and there was nothing in his testimony, identifying what he thought the effects of density would be, an increase in density on the site would be in the neighborhood, and what steps the applicant was going to take to ameliorate them. I'm not surprised, because there are no steps they can take to reasonably ameliorate the density increase that they seek here on the site. With regard to the height variance, the controlling case is Grass Over Spring Lake. This is addressed on page 8 of Mr. McDonough's report. Under Grasso, there are basically 3 things that a planner is going to look for. Is it consistent with the surrounding neighborhood? Would the new structure be out of place? Or would it degrade the appearance of the neighborhood? I'm not going to try and debate architecture. What's good in one person's eye is good or bad or different. But it's clear that a 13-story building opposite a high-rise in this community that has established a zoning district whose intent is to prevent that is clearly a degradation of the neighborhood. This community has established what they described as the criteria that created this neighborhood: ample setbacks, which this is not providing, not having high rises on both sides of the street, which this is doing. So clearly it's going to be inconsistent with the pattern that's been developed in this neighborhood under your zoning policies. Now, one issue that is also, I think, something that the board is going to have to wrestle with is the scale of the variances and their cumulative effect. Rather than trying to tick them off one at a time, what happens when you look at them together? You've got roughly 4 times the permitted floor area ratio, even if they have a larger tract, 7.5 times the density on a half-acre tract, 4.25 times the permitted height of a half-acre tract. None of these are what anyone would call a small degree of variance. And then when you get to the C2s, what are the directions of relief they need? Front, rear, both sides, height, coverage, lot area, width. Essentially every single bulk standard that would apply to this site, they need a variance from. That creates 2 issues, 2 perspectives that I think the board has to wrestle with. One of which is that this becomes more than simply a D variance. It essentially becomes a usurpation of the governing body's right to zone. That you're being asked to do too much on this particular track. And the other, there's a case out of Dover in which the cumulative nature of the relief essentially makes it a D1 variance. That's a case in which there are thousands of bulk variances, C2 variances, no D relief at all. But the court said you need variances for everything you're doing. And that elevates you in terms of the proofs that you have to reach. I'd suggest to you that this is an application, because it needs a variance from every standard, falls into that kind of category. This is more than simply a variance. This is asking you to do something, I think, above and beyond that which is appropriate. Now, to conclude, obviously I think this is an application you guys should not be approving. There was a lot of planning testimony that was provided by the applicant, much of which was not relevant to the proofs that need to be made before you. Fiscal impact. A theory of transition, that you went from a 20-story building to 3-story in town, and somehow 13 was on that line, and therefore it was transition zoning. That's no theory of transition zoning I've ever heard. Comparisons to New York City with block-long mid-rise development patterns, where clearly the West New York plan is trying to stay away from that. So you've heard a lot of planning testimony that had nothing to do, I think, with the proofs that are before you. It's ultimately my view that the applicant was trying to provide planning testimony where the proofs can't possibly be met. And that ultimately they failed to meet their burden because they can't square this with the intent and purpose of the zone plan. Not from a lack of skill on their experts' behalf, but simply because it can't be done given the nature of this application. So for those reasons, I would suggest and hope that you guys would deny this application.
Thank you.
Sorry, I have my back too.
Sorry. The negative criteria that you talked about, speak about relief being granted without substantial detriment to the public good and will not substantially impair the intent of the zone plan. Are you of the opinion, and so, if you need to refer back to what you said, are you of the opinion that, given what you said, that this also is substantially contrary to public good based on the testimony you've heard by neighbors and those who are living in and near the proposed site?
Yes, and I emphasize that while I thought it unnecessary for me to duplicate all of the testimony that you've heard, doesn't mean that I don't agree with it. I would adopt the architectural survey, the survey of the neighborhood, by both standards that are on each of those lots. There's a lot of good information that's been presented to the board, and I think it does demonstrate that there are substantial impacts.
So you're of the opinion that both prongs of the negative criteria, substantially detrimental to the public good and also substantially impairs the intent of the zone, purpose of zone plan, in both instances, this application both is detrimental, substantially detrimental to public good, and what you said about substantial impairment.
Yes.
Thank you. I have nothing further.
Chairman, can I just have 1 minute?
Absolutely. Okay, yeah, we can take a 5-minute break. Maria, did you get that, everything's moving. I know. They're in the coming.
You say basketball game?
Yeah,
Open.
Oh. Mr. Cullen, we were waiting for you to come back. Yeah, I know, Mr. Chambers. Probably get more coffee. Maria, excuse me, Maria, did you send Mr. Chapin for more coffee for board?
Very, very conservative. They have a cell?
Maria, you want to call him?
I'll come right back after
No, don't. But if you've got an order. I'm sorry, go ahead.
Yeah, they're up to nothing. Oh, good, oh yeah, we've got technology now.
Okay. On or off the record?
Any more coffee? I need
All right, why don't we continue the hearing? Mr. Alonso, do you have any questions of the objector's planner?
Mr. Chairman, I have no questions.
Okay, thank you very much. That being the case, actually, everything is done except for the board questions and the board decision. So,
Actually, Mr. Chairman, I'm bringing my witnesses back for any rebuttal. So now that the objector's case is completed, I'll review with them.
okay.
To the extent that I have any rebuttal, I'll bring it back at the next meeting. It'll be quick, and then the board questions.
And then Mr. Kantorowicz will be able to cross them on rebuttal. All right, so we're going to now continue the Meridian Boulevard matter. We're going to postpone it to the special meeting on May 6th.
Any questions by the board?
You wanted time to rebut it.
Right.
No, not
Let me ask, I understand. No, you're correct.
Because I don't want him to go without.
You're correct. Does any board member have any questions of the objector's plan? I don't see any. Thank you, Mr. Kantorowicz,
Just
for
to be
raising it.
clear, I'm not under any obligation to bring him back for further questioning.
By the board.
By the board.
Or by Mr. Alonso, that is correct.
Mr. Alonso, and
That is
unless
correct.
I see a reason to have a SIR rebuttal, he will not be back. And I want to be.
Okay, at this point in time,
Thank you.
Mr. Chairman, if I may just suggest,
yes.
I'll caution, we gave the public the right to question the applicant's experts. We should also-
Could you use the mic, please?
Does any member of the public have any questions of the objector's planner? I see no one coming forward. That being the case, this matter will be postponed to the special meeting on May 6th, 6:30 in these chambers, at which time, to whatever degree, Mr. Alonso said it will be very short, if at all. The applicant will be able to rebut. Mr. Kantorowicz will be able to cross whatever rebuttal there is. The board members at that point in time will ask questions of the applicant's consultants. And after that is done, the board will then render a decision on this application. That is for May 6th.
We need to ask the applicant if they consent
Oh,
to the.
you consent to the adjournment to the special meeting on May 6th?
May 6th, yes.
We may just out of abundance of caution, for instance, come on May 6th.
Or if necessary, if for some reason this roof falls, or whatever, do we have consent, if we cannot, if beyond our control, if we cannot have a meeting on May 6th, to have whatever is the next meeting after that?
I think at this time I can only do it.
Let's say the 28th.
At this time I can only consent to May 6th. I think we'll come across that bridge when we get to it.
Okay.
So,
Yes, sir.
Just two housekeeping issues, Mr. Chairman. Number one, I know that over the course of this meeting, this hearing, we've had different members sitting and so forth, and I know the applicant has expressed concern to reach an endpoint. If I could ask through the chair, however it wishes to poll his members privately or whatever, to be sure that those members who will be voting, hopefully quorum present on the 6th, have read and certified to and or listened to tapes so that they will be qualified.
I've already discussed that with our attorney, and I put it on his shoulders. No, he will be with our secretary and find out what board members did not attend what meetings, to make sure that they have the transcripts and whatever is necessary to be able to do the certification that you rightfully bring up.
I'm mentioning it because I don't want to
Absolutely.
have the applicant say, but what happened to.
Absolutely. Now, is there a second thing?
Yes, the other point was, the last time we had this type of hearing, Mr. Chairman, the chair asked for summations. Now,
All right.
I recognize that there will be further testimony, albeit
No,
relatively
you are,
brief, and
I am going to cut you off. You are correct, because I forgot that. So what we'll have is we'll have the rebuttal to whatever degree, hopefully, Mr. Alonso said it's very short. We'll have the cross-examination, if necessary, of Mr. Kantorowicz. Then we'll have the questions by the board members. Then we'll have, each attorney will be permitted 15 minutes summation. Then we'll have a decision by the board.
okay, one
You want me to say that again?
No, I just want to know whether it would be appropriate if I choose to submit a writing either prior to or at the
Absolutely.
meeting as a.
Absolutely,
as
Mr.
an
Alonso
outline.
also has that opportunity.
Thank you.
So on May 6th, it's rebuttal by applicant. And objectors' questions. Then it's questions by board members. Look, I'm missing something. Then it's 15-minute summation by each. And then it's board decision. All board members understand the significance of this meeting. The significance is finally we can get back to business. Other business.
Let's hope we have a forum because,
I think as long as everybody tonight is promising to be here, and this is a quorum. This is 6 people. Okay?
Mr. Chair, I am going to request a full board for a vote.
Well, that's 6.
That was 7.
No, we don't have 7.
There's 7 total. Oh, well, there's
Rose,
and
the
then
7th
Teresa-
member is
there's
not,
Teresa Cruz, who has it.
Yeah, four,
Cruz is no longer board member. He's not there. Oh, Elvira and neither Remo, neither William.
Yeah, no,
We
Teresa.
only have a 7-member board right now,
Okay.
and 1 has to recuse herself. So 6 is in fact your full board.
All right, I know that there were some
Yeah.
replacements, but I don't know if you have a full line.
That's my understanding is 2 people are no longer on the board, they have not been replaced. We have 7, 1 has recused herself, so we have 6. So that would be it. Okay, at this point in time, I would ask, would any member of the public like to step forward and make comment on the board's operation or behavior? Not seeing anybody coming forward, I'll entertain a motion to adjourn. Anybody want to make a motion? I second it, voice vote,
Hit the road, Jack.
Thank you very much, everybody.
See you, May 6th. Well, well, well.